minutes, please. And starting with Solomon Friedman.
Mr. Chair, Deputy Chairs, Honourable Senators, thank you for inviting me to address you today. Bill C-45 purports to address important public health and criminal justice objectives, namely to end the misguided war on cannabis and its ancillary effects and to legalize and regulate access to cannabis. Unfortunately, the bill falls well short of that mark in a few important respects. Much has been said before this and other committees with respect to the failings of Bill C-45 and the Cannabis Act that it creates. For my part, there are three primary areas of concern that I wish to raise this afternoon. First, the bill will be difficult to implement and apply in practice. Too much is left to the discretion of police. Apart from the discretionary areas, many of the provisions of the new Cannabis Act are confusing and assume knowledge and expertise on the part of frontline police officers that is simply not there. There are numerous examples of this throughout the bill. Police officers are expected to differentiate between flowering and non-flowering, and budding and non-budding plants. It appears impossible at present that police will possess the requisite level of horticultural knowledge in order to objectively and fairly enforce the law. Similarly, police officers must distinguish between permissible and prohibited quantities of cannabis. Is it 30 grams or 31 grams? For a young person, is it 5 grams or 6 grams? And even more problematic, an officer must determine whether or not the cannabis in question is legal or, quote, illicit cannabis, and whether or not the individual in possession of the cannabis knows that it is illicit. These determinations will no doubt lead to a host of unintended and unjust consequences. Imagine this occurring in the course of a simple traffic stop or a casual interaction on the sidewalk. Can individuals expect to be detained while an officer determines whether or not an offense has been committed? If so, for how long? Will they be provided with their right to counsel as required by the Charter? In addition, recall that the Act authorizes the issuance of search warrants, and in some circumstances, warrantless searches with respect to alleged violations of the Cannabis Act. The courts can expect applications to be made by officers who are not themselves sure that offences have truly been committed. We can further expect disproportionate effects on disadvantaged and racialized communities, as Cannabis Act searches and seizures are authorized and conducted where no warrant would otherwise have issued. Second, while the bill would allow for certain offences to be prosecuted by way of ticket as opposed to formal proceedings, and for the records of such convictions to be kept separate from other judicial records, this option is only available for those with the means to pay their fine within the set time period. The Act provides that this record suspension type procedure can only be used where, quote, the accused pays the amount within the period set out in the ticket. The law, as presently framed, does not provide for any mechanism to allow an individual who is unable to pay the fine to have his or her record of a Cannabis Act conviction to also be kept separate from other judicial records. In other words, the poor need not apply. This is not only unconscionable, it is also likely unconstitutional. As a result, the indigent and the unfortunate will be saddled with permanent records simply because of their inability to pay their fines. Surely, this cannot be Parliament's intention. I recommend that the section which currently prevents imprisonment for non-payment be amended to allow for the truly impecunious to have their Cannabis Act records also held separately from other judicial records, notwithstanding their failure to pay. Third, young persons who contravene the Cannabis Act are treated more harshly than their adult counterparts. This disparity stands in stark contrast with the fundamental principles and purpose of the youth criminal justice regime, namely rehabilitation, reintegration, and fair and proportionate accountability for young persons. Notwithstanding those principles, enshrined in the Youth Criminal Justice Act, a key benefit that this bill provides to adult offenders is unavailable to similarly situated young people. I refer to the record-keeping provisions of this bill. As of now, offenses with respect to youths cannot be initiated by way of ticket. In other words, a youth could end up with a permanent criminal record for an offense that, if committed by an adult, would result in a separate, inaccessible judicial record. If, for example, the youth were to commit another offense during the record access period, the Youth Cannabis Act record would be transformed into a permanent adult criminal record. This should be amended prior to the bill becoming law. I close with this final thought. The criminal law is a blunt instrument. It is ill-suited as a tool of social policy and reform. If the purpose of this law is, as the government has repeatedly said, to end the cannabis black market and the ancillary societal and legal costs that accompany it, Bill C-45 will not accomplish that. Those who would engage in the illicit trade in cannabis have not, to this point, been deterred by the host of offenses and penalties set out in the Controlled Drugs and Substances Act. It is folly to assume that the Cannabis Act will be any different. In fact, the tangled mess of regulation, discretion, and confusion created by this act may very well cause people to eschew the legal market and continue relying on illicit sources of supply, thereby defeating the very purpose of this legislation. Thank you very much for your kind attention.